Greetings to everyone who's watching. In this video, we share some of our experience in the field of railway matters. More specifically, difficulties encountered by carrier of goods by rail operating in Latvia. Today, we are joined by one of our colleagues, Andres Eglītis, with whom we have worked for many years in this area. Welcome to discussion, Andres.
Hi there, Mars.
So let me just say at the outset that we have been involved in this field since I think 2008. Back then, I think the difficulty was that charges for using the public railway infrastructure were not really set in a reasonable way, and we started litigating in this area. But then we started digging deeper, and we found various issues to address. Well, the bottom line is that in Latvia, the railway infrastructure is operated by a state-owned company. And that state-owned company has a daughter company, which is a railway carrier of goods by rail. And we acted for another railway carrier when we were faced with these problems. Essentially, what the problem was that somehow you had to go through your competitor, this daughter company of the infrastructure operator. And it presented all sorts of problems. Going through your competitor, sharing information with your competitor, it was impossible to operate in border areas without this competitor. So you had to go through your competition, which we found odd, wasn't it? It was a bit odd, Andres.
Well, it was very odd, but then again, it can easily be explained by historical development of railway in Latvia. So that's technically European regulations and requirements for a railway provide for one thing, and then you have historical railway heritage or something like which is basically inherited from Soviet system, where it's one entity which operates rail and does also business operations as a railway carrier. And it's a complex issue in a sense that it transcends one state, and it's on a Soviet level enterprise. And then you have to change and adjust it to the new legal framework that existed in the European Union. And I think that's the issue and the hurdle that obviously Latvian state and Latvian railway did not execute properly. And that's where all issues effectively emanate from.
So actually, the impression was that on the one hand side, you had this post-Soviet system in the railway area in Latvia. On the other hand, you had this European Union law, which was intended to liberate everything, to subject everything to competition, to end these monopolies. And the impression was that somehow the system in Latvia did not really want to change in accordance with the law of the European Union, wasn't it? That was the key issue, I think.
Well, indeed. And I think one of the things maybe why is that historically, again, Latvian Railway as a group of companies were one of the biggest companies and one of the largest employers. And through that rail system, it moved a lot of cargo. There was a big pile of cash flow moving around, and it's all was controlled basically by the state and effectively the government in power. And from one side, you have European regulations which say that this market in general should be made more liberal and you should allow competition in the market. And then on the other side, there are these financial interests of the Latvian state to continue to receive inflows in the state budget in the forms of the dividend or profits generated by Latvian railway.
So ultimately, what we did, we started complaining in Latvia to the Ministry of Transportation. We did a lot of complaining in Latvia, but somehow my feeling was that we were not really heard properly. Wouldn't you agree that in
I
Latvia our effort was not really that effective?
I would agree 100%. And again, probably for the same reasons that I already mentioned before. But yeah, so that's the sort of the idea is that if you can point to applicable regulations, which are basically directly applicable laws, which the member states of European Union should follow, we did not receive the same kind of support as you would expect in transitioning
Yeah.
to these new rules and following them. And even when there's issue, then well, that maybe historically that it is there, then you ought to find a solution. And then it's fine if you actually look for a solution and try to mitigate the wrongs of the past. But this is actually was not the case, and I would say it was other way around. That such activism actually drove some backfire, and then we saw that there are new ways how well
How to
basically
intimidate, how to make life more complicated.
exactly, yeah. So that's our experience in that
And then
those matters.
ultimately, the Latvian Competition Authority started investigating what was going on, but it was painfully slow. It was painfully slow. I think people were changing, these investigators were changing. And then at the end of the day, we were suggesting and insisting that probably the right place where to seek justice was to complain to the European Commission. And finally, we did. And I think that triggered something. At least they started looking into this issue, probably made some phone calls, approached colleagues in the Latvian Competition Authority, and then something happened. Somehow this investigation moved on, and finally they found in Latvia that there was a problem, which I think was a very big success. I, at some point in time, I no longer expected that something good would come out of this. But we kept pushing, we kept sending emails, we kept complaining, we kept reminding, we kept ringing alarm bells, and ultimately something moved. What is your impression? What triggered this change? What triggered this decision of the Latvian Competition Authority? Do you not think this is to do with the European Commission?
I think it is actually has to do a lot with the involvement of European Commission and European institutions in general, and with a general principle that they acknowledge that there is a problem in Latvia, that there are issues that the market participant is trying to deal with and does not get any assistance or even acknowledgement from local authorities. And it was and in essence the grounds, the legal basis for all complaints and the points that we argued were mainly based in European law, European principles of
Yes.
how the railway undertaking should operate.
And
And
what is
then
happening now? And what is happening now? Now, well, I suppose it would be naive to think that the Latvian railway company, the operator of the Latvian railway infrastructure and the daughter company would accept it. Or perhaps it wouldn't be naive, it would be normal to expect it, but they haven't accepted this decision of the Latvian Competition Authority. So they're litigating now. So the Latvian Competition Authority is litigating with this railway operator, the infrastructure operator, and its daughter company, and it hasn't been finished yet. I think they're litigating for the second year, and it's far from over. It is far from over. And in the meantime, what the courts have said, the railway carrier who has suffered all this inconvenience, that railway carrier was not even allowed into this proceeding. They said, no, this is not your place here. We don't need you. So in a way, that means that the railway company owned by the Latvian state is litigating with an institution of the Latvian state. It looks like two arms of the Latvian state are litigating, wouldn't you say?
It's exactly as you described, and it's basically the question of payment of the fine. It's it would come from a state budget and would be paid into state budget.
So
So
from one
that's
pocket into another.
exactly. So that's something that at least again from the government points of view didn't create any negative consequences. The other thing is that maybe if this issue would have been raised and the investigation had been transferred to European Commission, then I believe the fine does not go to Latvian state budget, but rather has to be paid to European Union. So that's another, again, sort of just analyzing from interest point of view, is another incentive why, after acknowledging that there's a direct European interest in this matter, to start the investigation to bring it to certain fruition in adopting a certain decision, and then litigating about it and dragging the whole process for many years, and at the same time basically blocking the independent railway undertaking from seeking proper remedies and for the wrongs that have been incurred by these unlawful business dealings.
So it looks like the plan was, or might have been, to keep the whole matter in the house, in the family, so to speak, so that it does not become a European issue, and so that any fines stay in the family.
Well, if we analyze from how it has turned out and where it's trending, I would say that this is how you can read the situation. So I'm not sure whether we can claim 100% that was initial plan, but this is exactly what is happening now at the moment. So, well,
do you remember that during this investigation, we also wanted to obtain the so-called security license for the client to operate in border areas, and that turned out into a nasty litigation as well, because this railway inspectorate opposed, and I think ultimately when we got to the Supreme Court, that's what triggered a change. And now, from what I know, the client has obtained this security license to operate in border areas. But we were met with fierce resistance. So it's not like just it's the railway company that was causing trouble. It is also this railway inspectorate which didn't want to see the light, as I see it. So fierce opposition, wouldn't you say?
I totally agree. And on top of that, there's another issue, is that we had to go to Supreme Court, which means we had to go through the court of first instance, which basically said that our claim is completely unfounded and wrong. We went to the Court of Appeals, who basically upheld the decision of the court of the first instance. And then effectively, when we got to Supreme Court, which is the third instance, it's just basically was the first time where the European law that we actually argued from the beginning was analyzed. And it was indicated that something is wrong, that it shouldn't be like that, and the European regulations specifically provide for various tools and mechanisms how to support such independent railway undertakings which try to access market and actually create competition in the market.
Well,
And
let's say that old habits die hard. I can say old ways also die hard. And well, I suppose then we could end this short discussion by saying that it was probably necessary to go to the European Commission to trigger this positive change in Latvia. At least that's my understanding. And well, usually this is what we recommend to our clients. Whenever you have a chance to go to some international organisms, whenever you have a chance to go to the European Commission, that draws attention to these issues in Latvia. And somehow, when people in Europe have been alerted, usually it brings a positive change. I think that's what we could conclude, more or less.
I agree 100%.
Well, thank you for this discussion. Thank you, everyone who's been watching. And until next time.